I gotta turn it off. No, I'm doing it quick. Sorry, I keep teasing you. Okay, so we're going to transition to a very different topic. Florida Health Freedom and the legal panel. Nate Gorman is going to speak with us today. He works for the National Health Freedom Coalition and the National Health Freedom Action as a legislative and policy advisor. He's an experienced professional lobbyist who worked for nearly 2 decades in Colorado. His work contributed to the successful passage of Colorado's Safe Harbor Exemption Bill in 2013. Today he is based in Florida, helping heal freedom activities or activists across the United States. And remote via Zoom, we have Petra Boken. She's calling in via Zoom and is a staff attorney with National Health Freedom Action and National Health Freedom Coalition. Her area of focus is the Safe Harbor program. You want to come on up? We're getting there.
There we go. Okay, thank you everybody. And we're going to let Petra start. She has a presentation for you.
Recording in progress.
Where she will give you the information on what Safe Harbor is. And then after her presentation, she'll be available for questions. And I'll also be able to talk to you about what we do to help pass these bills in the different states, working with legislators and public policymakers to enable the ability of complementary and alternative practitioners to perform their healing practices without running afoul of the state laws that currently exist in many of the states. I'll turn it over to Petra, she can hear us.
Yeah, hi everybody. I'm joining obviously virtually from Minnesota, and I do have a presentation, a Zoom presentation, and I can start with that now. I'll need to share my screen. I don't know if anyone else has anything to say before that, or should I just go ahead?
I think you're good, Joe.
Okay, then I'm going to share my screen. Okay, I need to get rid of this toolbar somehow and start with the slideshow. Here we go, from beginning. There, okay. All right, so my name is Petra Boken. I'm a staff attorney with National Health Freedom Coalition and National Health Freedom Action, the sister nonprofits. And I'm here to talk about our Safe Harbor bills, Safe Harbor laws that protect holistic practitioners and the people who want to access them. So, for me, when I look at health freedom, bodily integrity, when I look at the laws that we help people pass, it has to do with our ability in this country and in many places in the world, of course, to think about and access the type of healing that we want for our bodies. So that does come from case law in the United States and some constitutional rights. But when we look at occupation, when we look at the right to practice versus the right to access a practitioner for the type of healing that we want, there are different types of laws that are involved. There are state laws and there are federal laws, and they each have a different aspect of of looking at holistic healers and what they can and cannot do in the United States. So the main thing for occupations is state law, and for things like supplements and other remedies, that is federal law. The state law of practicing an occupation has to do with, are you helping somebody with a health problem? And the way that states regulate that has to do with the police powers that are provided to them through the Constitution. So the police powers have to do with that they can protect the health, safety, and welfare of the people in that state. So when something is dangerous for the health of the people in the state, then the state gets to step in and go, okay, great, we can license it, we can regulate, we can do something about this to make sure that everyone in the state is safe. And we can restrict your individual liberties, your right to have a profession, your right to access a professional, if it's for the general good. But obviously the state can't just say everything gets to be regulated, so it has to be reasonable, and there are other precautions in place to protect people's rights. So how do they do it? Well, again, they require licensors if it's an imminent risk of significant harm, because really there are so many things that can cause harm. So it isn't just that it can cause harm, it is that it has to be an imminent risk of significant harm, because otherwise, one example that's used quite often is drinking water. If you drink gallons and gallons and gallons and gallons of water, you could potentially die. And so should there be a license to provide water to someone? Well, of course not, because that's not an imminent risk of significant harm. So it isn't anything it's not any practice that has any potential risk if you do it wrong, or if you, if you give way too much of it, or if you don't exactly, that it has some theoretical harm. It has to be the imminent risk of significant harm. And each state is different. So when it comes time for questions, you may have questions about how this applies to you and your practice, or your access to practitioners in your particular state. I, as an attorney, cannot give you legal advice on your particular state and how that would interact with what you want to do. You would need to access an attorney in your state to do that, because each state is different, and I can't represent you and find that exact information for you. So with government licensure, when you're a licensed practice and you want to practice under a license, and what you're doing is you're giving the government, if you agree that what you do is dangerous and they therefore can license you, then practicing without a license is illegal, and it can potentially have criminal or civil penalties. You potentially can't use particular titles. So this can be very oppressive to want government licensure, or to have when the government licenses a particular type of practice. Also, what you do is you give the government the ability to say what you can and cannot do. So, and oftentimes the government wants to restrict it more and more and more and more. And they usually don't understand the practice of what you do, because it's some government official that's deciding what is good for that particular healing modality and what is not, instead of the people who are doing it themselves deciding what is good and what isn't. So what happens is you have, in a state, you have many, many different types of laws about occupations. So in all states, there is the practice of medicine. I live in Minnesota, and the practice of medicine here, the law is that anyone who's offering or undertaking to prevent or diagnose, correct, or treat in any manner, and listen to how broad this is, by any means, methods, devices, or instrumentalities, any disease, illness, pain, wound, fracture, infirmity, deformity, or defect in any person. Any violates a gross misdemeanor, you can go to jail for a year. And then, so again, you can see how each state is different here. In the state of Ohio, you have the practice of medicine, and here you have, the words of whatever nature, for the cure or relief of all these different types of things. And here, compensation of any kind, direct or indirect, you didn't see that in the Minnesota statute. So you have to look at the actual state, in it's Florida. But Florida has several different laws that are complex in terms of how you take a look at the practice of medicine. You see that Washington, and I know there may be people here at the conference who are not from Florida, so you have to look at your particular state. Here it is, even in Washington, real or imaginary. You have the state of Maine. You have things even, furnishing a drug, medicine, appliance manipulation method or therapeutic agent, and then you need a license. Maryland, so not only do you need to look at the laws for practicing medicine without a license, or for practicing medicine and the definition of practicing medicine, but you also have to look at the laws for things like chiropractic, for naturopathic medicine. So there's all the different laws that need to be looked at. And so they also have the laws about what you can and cannot do. And the state of Maryland, it's a felony. In Kansas, it's not even a natural right to be able to heal. So from our standpoint, people heal each other as a natural way of being. We heal each other when a parent gives a child chicken soup, when we put a Band-Aid on a child. We heal each other and our families on a regular basis. And these these types of acts in many states without safe harbor laws. What you're doing is you're practicing medicine without a license. Now, obviously, most times the state doesn't prosecute this. And it's only usually when there are complaints about a person practicing that the state gets involved and then tries to shut it down. But then these laws are so overbroad that anything can be illegal. So when you have government licensure, there are various hazards involved in that, and you can get turf battles. You can have licensed people wanting to shut down the unlicensed people. You only have the certain people who are licensed that are making more money, and then the unlicensed people, even if many are falling under the license, or even if there is, some of the people are having different qualifications. Slowly, those people with the lower qualifications are often driven out. You have policies, again, enforced by people who don't understand the practice. You have punishments, you have prosecution. You just don't have as many people practicing that holistic practice. And again, the boards that don't understand the profession. So what is our solution with this? Our solution are the safe harbor, state safe harbor practitioner exemption laws. So when you have the Medical Practices Acts, and I'm sorry I don't have the Florida one in here, then what the safe harbor law does is it exempts out the natural healers from the licensing as long as they do certain things, as long as they provide the client bill of rights, and as long as they do not do the prohibited conduct. So what we do is we help people pass the laws to do this type of thing where the safe harbor law protects the health freedom. We have an attorney staff. I can help research and draft a law, and actually we already have a Florida safe harbor law drafted. We have a long form and a short form, and if anyone is interested in working on this, you can email us or call us, and we can meet with you, and we can help with we potentially have others here working on it. I don't know whether Nate's talked about that or not. We are looking for sponsors. So we do have people interested, and I know that your organization has also been working on this over time, but we do have some potentially others working on it, and we can begin to meet again if there are people who want to work on this. So we can help support that again. If there are people who can, who want to step forward. So when you have an exemption, the exemption allows people who want to do complementary alternative healthcare and to their so then the Practices Act does not apply to them. So they're exempted out. Some of the safe harbor laws define what the complementary alternative practices are, and some do not. And sometimes groups don't want it all defined, because then if you're not in that group of definitions, then maybe they don't want to allow you to be exempted. And some do want a list. So Maine does not have a list. And again, we've written different versions for Florida. It depends always on the group that wants to go forward with it. And Nate can speak better on this, but I know this is the time when it would be good to really move forward a bill in Florida, so that things can be ready with a sponsor and before the session starts, which I believe is in January. So this is again a different type of exemption, so that you're not violating any law unless you do the prohibitive acts, like performing surgery, setting fractures, doing x-rays, administering prescription drugs, this sort of thing. And Arizona has a homeopathic license exemption. So then you have, again, lists of prohibitive acts that you can do. And these lists change with what the people in the state want. Then you have a Bill of Rights. So what are you going to do? You have to disclose things. You have to say that you're not licensed. You have to give the nature of the services provided. And we've had a great deal of success in passing these bills. One terrible thing that happened was Wisconsin, where it was vetoed by the governor. So sometimes things can be difficult. Massachusetts is working on a bill. We do have 11 health freedom states, and we have states that are active, including Florida. So when you license, this is skipping ahead to licensing, and I'm doing this kind of quickly because I want to leave time for questions, but when you license, you still have to operate within a certain scope, and you still have to, there's a standard of care you have to operate within, which doesn't always allow you to do exactly what you want. You have to operate within the standard of care even if you're licensed. So licensure doesn't automatically just open everything up. And here is the people who are prosecuted for standard of care issues and can lose their license based on the standard of care. So this has also been a very big issue that we have health freedom answers for, but that's not really, I know, what's happening in Florida in terms of what we're talking about today. So federal law is the Commerce Clause, and that allows the federal law to regulate dietary supplements and homeopathic remedies. What we're looking at is drug law versus the state law that has to do with being able to have an occupation and go to see someone and have access to people who practice holistic healing. So drugs are not food. So most supplements now are considered food, and they are not they're not considered drugs. So dietary supplements, U.S. dietary supplements, we can obviously give them, which is different from homeopathic remedies. So we we also provide draft remedies for draft language for homeopathic remedies. So that is the support we give, and that is basically the outline for looking at safe harbor in Florida. And what I can perhaps do, while maybe someone has a question, is get the Florida bill that we have and put it up on the screen, the draft bill, so people can look at that as well.
Okay, thank you, Peter. And what I'll do is I'll give my remarks, some brief remarks, and then we can come back and any questions involving legal questions, I'll turn over to Petra if she can answer them, if she's allowed to, or if it gets too much into an individual interpretation of the state's law, then she will defer to securing a Florida licensed attorney. So I doubt, well, what we're talking about here is law. And I don't think, there may be some attorneys in here, but law is words that govern how we live and what we can and cannot do when people are sent to both the state capitol or the federal in DC or whatnot, or even your local county commissions and whatnot. They are passing laws and ordinances and whatnot to govern our conduct. And the words that they use are used very intentionally. And having been involved in a lot of bill drafting, we take a lot of care to make sure we're saying exactly what we want, because once a law is passed, it can have unintended consequences. It can be interpreted differently by judges than we intended when we're writing it. And so we try to be very precise in our language. And when you see Medical Practices Act that is so broadly defined, that's where the peril comes in, because you're operating and you think, hey, I'm just healing and I'm not doing anything dangerous and I should be able to do this. But the Medical Practices Act in every state is so broadly defined, anything you do, including the giving soup with the intention of healing, that will get you into trouble if somebody complains, if there is a reason to investigate or complain. And the key to that, the word is intentional. And so the act of just giving chicken noodle soup isn't any kind of crime or violation of Medical Practices Act. But if the soup is being given to heal, that's where the peril comes in for these things that they will consider to be unsafe if done in the hands of somebody who doesn't possess proper training and license and all that kind of stuff that they've defined. What we are trying to do is create language that addresses that ambiguity, that broadness of the definition of the practice of medicine, so it brings it back down to the core of what passing a law to regulate an occupation is intended to do, which is protect the public health and safety and welfare. And so when you are regulating acts that don't pose the substantive risk that Petra was talking about, then you're kind of getting into things like, well, I want my credentials to matter more than somebody else who doesn't have my training. Maybe somebody else has other training that's comparable, but they don't have yours, and you want yours to be the standard for everybody to have to practice. It could also be for monetary consideration. There can be laws that are passed to basically prefer one business model to another, one group of business providers or occupation professionals to another. It becomes kind of like proprietary, and that's putting the weight of the government, the thumb of the government on the scale of these practitioners and choosing winners or losers. And so a lot of times that happens when you're regulating things that don't pose a significant risk of harm to the public, but you're regulating it anyways because, well, the political process does have different types of challenges in terms of what is really necessary and then what might be done as a favor or other kind of biases that might be in the public policymaker's interest or whoever is talking to them about doing it. And so the words that are chosen in law matter, and even though you're not attorneys and you're not going to be expected to know exactly what the law says, you do and should, when you're doing your practice, at least have access to attorneys who can give you that guidance and steer you around the hazards that are out there, because if you were to be the subject of an investigation, that can be very costly to you in terms of defending yourself, in addition to shutting down your business and possibly doing criminal jail time. And this happens. There's currently somebody here in Florida that is under investigation of practicing medicine without a license, facing 20 years. And it was for practices which did not have an inherent risk of harm. but they're being currently prosecuted right now in Florida. I do know there's many folks in here who I've spoken with who are not from Florida, so that's why we talk about the other states that are out that we will help. And what I do is I take my experience of 20 years lobbying, and I did lobby and help pass the safe harbor bill that we have in Colorado. And I'm familiar with a lot of the objections that I will hear from legislators, from the different interest groups that are out there that would oppose what you're doing for their own reasons. Maybe they sincerely think what you're doing is harmful. And it's not that they have anything, personal against you, but they believe in their system of medicine as they practice it is the only way, and anybody doing anything else is selling snake oil. They're the quacks and whatnot. They love using that term for things that they don't understand. And so what you don't know, you fear. And if they don't know what you're doing, they're fearful of it. And they say, well, if I'm not trained in it, then it must be dangerous. Or I don't want these people who are unlicensed getting in the way of my healing, and then I have to clean up their mess. And you'll hear that from a lot of the medical profession that's out there. And to the degree that that may or may not be true, one of the things that Safe Harbor does is you're out there. Homeopaths are out there. Herbalists are out there. Reiki practitioners are out there. TCM practitioners are out there. They're operating. You're doing what you're doing now, even in spite of the law of the Medical Practices Act saying what it says, and that you shouldn't be doing what you're doing. And because of that, the customers that you're seeing, they may not be forthright and honest with their primary care physician. They might feel embarrassed, ashamed. They don't want necessarily to write and raise their head and then have the primary care physician target them. Oh, you're doing this, and you should be seeing me. I'm going to send the state medical board against you and try to investigate you. And so you don't have that communication that you need. If somebody has multiple different systems of health that they're accessing, some of those things might not work well together. And if you don't have open and honest dialogue between what you're doing and what the primary care physician is doing, and the person who's treating them for whatever the malady is that they're in for, you could have some dangerous things that nobody wants to happen. And so by passing Safe Harbor, it pulls you out of the shadows that they know you're in. It pulls you out of the shadows, and then you're able to then work in a collaborative manner with the physician who would be providing the care that they're getting. So it actually is a public safety effort when we're pushing Safe Harbor, and they'll say, oh no, you're going to open it up to dangerous practices. You're doing what you're doing now anyways. But then it opens it up to that collaborative, helpful, type of practice where the communication is there and you're able to do what's in the best interest of the patient for them, your customer for you. And by doing that, then that improves the overall health, safety, and welfare of the general public, and that's one of the arguments that we make when we're trying to pass this, is because there's just the fear is out there saying what you're doing is dangerous. And by keeping you in the shadows, that's more dangerous. And I'll take that as a cue to wrap up my remarks for now, and then I guess we could open it up to other questions that you're going to take.
Yes, we can take the questions.
Well, I've got the Florida short bill, so I drafted a Florida short bill and a Florida long bill. This is the short bill. Can people see it up there?
Yes.
So this is you can see that we have kind of a little thing in the beginning, I'm missing the word, that kind of shows, well, of course, the title, but then also a little introduction about the state of Florida and the history of natural healing arts, and some more information about that, because when you have a state that has particular groups of people who are interested in natural healing, it's kind of nice to bring those in. We included a National Institute of Health report, which talks about, in 2016, how Americans spent $30.2 billion out-of-pocket dollars. This is something, again, that's very interesting to legislators, because everyone wants a good economy, and how this supports different ethnicities who want, in different religious groups, and different, all kinds of different peoples who want to access the type of healing that they want to access. So this would be the Unlicensed Complementary Alternative Healthcare Act, and then you go to definitions, and you define the unlicensed complementary alternative healthcare practitioner, in this one, you can see that there's a list of different practices, and that you don't violate the licensing requirements unless you do the prohibited activity, fail to fulfill your duties, and the prohibited acts are performing surgery, x-rays, fractures, setting a fracture, these very physical things that generally medical doctors do, or chiropractors. You can't tell someone to discontinue their medical treatment. You can't hold yourself out as a licensed healthcare practitioner. You can't provide a conventional medical disease diagnosis. And so these are the sorts of things you can't do in this particular draft bill. And then again, what are the disclosures? Name, business address, phone number, what are the nature of the services, what degrees, training, experience, and credentials do you have? So here again, if you have a lot of credentials, that's something you can still use. The Safe Harbor Bill allows the credentials to still be out there. It just doesn't mandate particular credentials. It allows the type of holistic healing to monitor that themselves instead of giving that to the government. Then it has to be signed, and it doesn't affect other healthcare practitioners. So that is the short form of the draft bill that we already have for Florida.
Thank you, Petra. And so we have a bill that's ready for introduction into Florida. What we don't have is the bill sponsored. And we have had some meetings with certain legislators who are interested in it, but we don't have a commitment. And we're right on top of the deadline for the upcoming January session for bill language to be introduced by legislators. And so one of the things that the organizations, and I should say, people who are interested here in Florida have been struggling with is to find that bill sponsor that will take the flag up and charge up that hill, because it's going to be a tough battle going against the entrenched, medical interests that are here in the state. It's very, very powerful. And what you can do, what can you do is, if you are able to meet with people who are either currently elected officials or running for office as candidates, meet them, get to know them, let them get to understand what your concerns are, and how there's a solution for one of the things that you are running into in your practice, and being able to be more free and telling other people about what you're doing. I mean, right now I'm looking for an Ayurvedic practitioner in South Florida, West Palm Beach area, and it's hard to find, that person, that person listed, in a place that I can trust, because a lot of folks they'll take their clients word of mouth. They don't want to get too high of a profile out there for what they're doing. And so passing Safe Harbor allows you to market what you're doing more freely and openly. And if you can find people who are running for public office who can be making laws, then we can help that process along and help you learn how to talk to legislators. That's my job. I did it for 20 years. How to navigate the process. If you run into an obstacle, it may not be, something that you can't get through. You just have to have, some creative thinking on how to get by it and pull in some other ways to navigate that. And I'll leave it at that. I know we're getting some time pushes here in terms of being able to move on to the next one, but I think we're going to open it up to a few questions, and if there's anybody who has questions, either myself or Petra will get the mic to you, and I don't know.
We can do later, because now we don't want to be off the schedule.
Okay, sure.
Yeah.
Here we go.
Just to, I have already shown 1 minute. Oh, I know.
I just want to clarify if I understand this correctly. So I think a license is a privilege, and with that privilege is also limitations come, and the limitation is every license has a scope of practice. So if I step outside that scope, then I'm going to be penalized, I can be arrested, I lose my license, so there will be punishment. So I'm an allopathic physician, and there's a scope of practice that I can prescribe these medicines and that. But from this conference, I'm learning a lot of Ayurvedic stuff. That you can put some nasya oil in the nose to cure or treat neck pain, or you can use Pindaswain or something to cure the back pain. If I prescribe that, or suggest even, not forget prescribing, I'm going to write in a prescription pad and give it to the patient. But if I tell the patient, hey, this might help your back pain, I've done whatever I know and it has not helped me, or this can help you in neck pain, and go to this Ayurvedic practitioner and she can put some oil in your nose and you'll feel better. Am I going to be in trouble if I do that?
I'm going to set this up and then Petra can kind of fill it in.
yeah,
But we
right.
do have another program that we're working on around the country that we've introduced recently called Expanded Practices, allowing those people who do have licensed practitioners and licensed occupations to go outside the scope of practice and not be fearful of losing their license. So Petra, if you want to address this.
Okay, so I guess I'm unsure. You're talking about a situation where a medical doctor is also doing this?
Correct.
Because I guess, licensing is, you're saying licensing is a privilege. Really, licensing only has to do with, in terms of the law here, it has to do with what is considered dangerous. So it has to do with the state saying, if you do something dangerous, I mean, medical doctors, harm people all the time, right? In various ways. You can do the wrong kind of surgery. You can take off the wrong leg. You can, give a drug that has a side effect that kills somebody. I mean, so when you have a practice, a healing practice that can injure someone, that is when the state gets to come in and say you need a license, and we're going to regulate you. So if you are doing something that is not dangerous, like giving somebody mustard seeds, that should not, from how we look at it, fall under something that should be licensed.
We're talking about
Because-
expanded practice pages. We're talking about an expanded practices rationale.
Right. But expanded practice has to do with people who are already
And
licensed.
that's what this gentleman is a doctor, medical doctor, and also wanting to integrate.
Oh,
this.
okay, I did not, that was my question.
Yeah.
Are you talking about people who are already medical doctors?
Correct.
Yes. So if you're already a medical doctor, then you can be shut down also by not practicing the standard of care. Right? So it would depend, and the standard of care, of course, as I'm sure you know, has to do with something that's very loose. It has to do with what, most of the doctors in your position would do versus what actually would be the most beneficial for that patient. So, that's something I can't answer. I don't know what the standard of care is for that particular patient. But we do have these expanded practice draft bills that are also available and could be passed at the same time that a safe harbor bill would be passed, and they could go in at the same time. And these laws, there is one now that was passed in Utah, and that's really the one that's been the most protective, because the other laws that are trying to protect licensed medical people when they want to go outside of the standard of care have not discussed the standard of care, and so they're not really protective. And you saw that during the pandemic. You saw licensed medical doctors wanting to go outside of the standard of care and, for example, give ivermectin or give other things for COVID-19, and they were shut down. And they had licenses taken away because that was not within what was considered the standard of care.
Okay,
So really,
That
I'm
was
sorry, go ahead.
I had a correction here. Actually, I heard it as expanded practices, and I've been corrected. They want to know if they can make a referral, a medical doctor can make a referral to holistic healer Ayurvedic doctor without losing their license.
I mean, I guess I would, I wouldn't see why not, but that's something beyond what the scope of this presentation, and it has to do probably the laws of Florida and the laws of, the medical laws that you're practicing under, but, I guess I wouldn't know anything, would be wrong with that. You should be able to refer to whoever you want to, but I can't give you any legal advice about that.
Okay, thank you, Petra, and thank you
Oh, you're
everybody
wondering,
here.
maybe I'm misunderstanding. Are you wondering whether Ayurvedic practitioners could practice under you?
No,
Like you would have someone
you actually answered the
who is
question.
allowed to practice under your medical license. And again, that
That's
would
not
have
the
to
question.
come
I'm so sorry, we're way
Yeah.
past time about, you answered the question. Thank you so much.
Okay, great.
Thank you.
Yes, it's hard because I can't see anybody.
I know, I figured so. Thank you very
So I'm
much.
kind of drifting in space here.
Yeah.
But,
Thank you very much.
okay,
Bye.
all right, bye.
Thank you.
Awesome, thank you very much. Okay.